Welcome, welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. Well, have you missed me? My students have been busy taking an extended take-home examination on the principles of First Amendment law, and then they spent some time crafting what I described in video 22 as student position statements. Now, I won't go through all of the parameters of the exercise, but I'm here today to summarize for you some of the position statements that were presented in our recent class meeting. Now, but I can't resist. So the position statements had a number of goals. One goal was for students to review what they've learned about the First Amendment and apply it to current First Amendment conflicts that we are experiencing in 2021 in America. A second goal was for them to work on their writing. They prepared 3-page position statements, going through the case law, going through the factual, the factual incidents that suggested is a current conflict. And they had to argue the opposite side and their own side. So they had a goal of reviewing, they had a goal of working on their writing, they had a goal of applying the First Amendment to issues that really matter to us as a country. And they had a goal. They're presenting their statements. They have 5 minutes to explain their position and explain the competing positions, the opposite positions in the classroom. So another goal is to work on their being persuasive, but at the same time being open to disagreement and open to hearing other perspectives. So today I'm going to tell you about the first, the first 6 position statements that were presented in class. And I want you to think about their positions and ask yourself, do you agree with the students or do you disagree with each student? If you look in the text box, you will be able to see the titles of their position statements so you can keep up to determine whether you agree or disagree with each individual student. Okay, so let's go to the first statement. Oh, those are my notes, I'm sorry. Let's go to the first statement. So one student, this is what he argued. Let me go back and say, I'm just so excited to get to the statements. Let me go back and say these interpretations, these summaries of the student statements are my own, as with the case law that I will be interpreting here for you. For my students' privacy, I am not using their names or disclosing their identity. Who knows, in a few years, they may decide to change what their position was. So for informational purposes only, I'm a professor at Mississippi College School of Law, where I've been teaching now for a number of years, but I've been teaching in law school and business schools for almost 30 years now. These views are not to be assessed to my school. Okay, let's get with it. So my first student, here is what he argued. He said, speech that directly advocates another to commit suicide should be an additional category of unprotected speech under the First Amendment. Now, do you agree with him or do you disagree with him? So Remember, we talked earlier about categories of unprotected speech, that not all speech is protected the same under the First Amendment. The court has held that there are certain categories of unprotected speech where government may regulate the content more, right? We numbered off some of those categories: speech that advocates illegal action, fighting words, obscenity, defamation, and the court added a category in the Ferber case, speech with certain depictions, sexual depictions of children. So those are the unprotected categories the court has recognized. My student argues that an additional category should be added, that government should be able to regulate under a lower standard of review or regulate more freely speech that directly advocates another to commit suicide. Now, he says that there is a current conflict here because there have been some cases where individuals were charged criminally for directly advocating for another to commit suicide. And he says that speech ought to fall in an unprotected category. Now, he also addresses some positions different from his own. Remember, they were required to not just argue their own position, they had to address the competing or the opposite of positions. He said some people may say that why add another unprotected category of speech? We already have speech that advocates illegal action. And, in terms of suicide, people say, well, how is that illegal? Don't you have a constitutional right under the federal Constitution to commit suicide? No, the court has not so held. Now, in some states, they do afford a right under state law, a right to suicide, and perhaps also a right to assisted suicide. But under our federal Constitution, the court has not specifically articulated such a right. So his position is that for individuals who do this, he said that there are people who are vulnerable, and especially during COVID-19, there are individuals who are mentally vulnerable. And if someone is advocating or directly encouraging for them to commit suicide, they ought to be punished because of, for one reason, because of particular vulnerability among young people. Now, I asked him several questions, as did his classmates. And one question I had for him was, how do you determine what is directly advocating for a person to commit suicide? Now, some people, not me, but some people, when they argue or when they get mad, they may say some very hurtful things out of their anger or what have you. They may say things like, I wish you were dead. So what if a person says that? Is that advocating for a person to take their life? And would that speech be unprotected under his position? Well, he said that's why, he said likely not, because he is arguing that the speech must directly advocate for a person to take their life. And in that instance, he believes the speech should be unprotected, not protected, under the First Amendment, which would allow government to regulate it more. So, what do you think about his position? Do you agree with his position or do you disagree? Make a note. I have some more to come. My next student also argued that certain speech ought to be unprotected under the Constitution and outright banned. Here is the title of her position statement. It's the second one. She said, the Confederate flag should be banned from public areas due to the fighting words doctrine and the advocacy of illegal action doctrine. So she argued that the Confederate flag should be banned from public areas. She argued that the Confederate flag is speech that is advocating illegal action, or it is speech that is fighting words, therefore it should be banned from public settings. I asked her, would she carve out an exception for museums? And it seems, if I recall, that she said there could be some exception as long as the museum was not glorifying the Confederate flag. So in her position statement, in her factual basis, she points to the use of the Confederate flag at involving several different incidents, but I will mention two here. First of all, she pointed to the use of the Confederate flag when 9 people were murdered at a church in Charleston, South Carolina, and how the Confederate flag seemed to figure prominently with that criminal defendant. She also pointed to the incidents at the US Capitol on January 6, 2021, and how the Confederate flag was displayed prominently there. And we're going to have some other position statements in the coming weeks addressing January 6, 2021 at the Capitol. Now, she looked at some positions opposite hers. And one, she said, people may say, how are you going to ban the Confederate flag? A government may choose to fly a Confederate flag as a part of its government speech. And I'm sure, as many of you are aware, in Mississippi, we just recently changed the Mississippi flag. And so she says, of course, the government has a right to speech, but she disagrees with this speech and argues it should be banned. She said another position is that, well, if this speech is fighting words or a speech that advocates illegal action, why do you have to carve out a separate ban? Now, her position is this. Her position is that the Confederate flag is speech that advocates illegal action. She argued that it is the celebration of when several Southern states seceded illegally from the Union. And so therefore, it is speech advocating illegal action. She also argued that about, as fighting words, that the Confederate flag, while she cited some statistics where maybe a third of people said they saw the flag, the Confederate flag, as a symbol of racial heritage, She said the majority of people see the flag as a symbol of hatred and racism, and that it may be enough to make a person want to fight, and that fighting words are unprotected under the Constitution. So her argument, her position is that the Confederate flag should be banned from public areas due to the fighting words doctrine and advocacy of illegal action doctrine. Do you agree with her? Do you think the Confederate flag should be banned from public areas, or do you disagree with her? Make a note, keep a record as we go on to the third position statement. Now, the third position statement also touches on a form of unprotected speech that we've talked about before. Let me read the title and you'll see what I mean. His statement is revenge porn laws versus the First Amendment. Revenge porn laws should not be prohibited by the First Amendment. So he says that laws that punish revenge porn are not in violation of the First Amendment and ought to be allowed under the First Amendment. Now, he points to a couple of incidents where there were individuals who consensually created some pornographic videos. And then once the relationship fizzled, right, or after there was a divorce, then one person who was quite upset about the relationship ended, just to get even, leaked the videos showing the pornography. And one of the individuals who was a public official or a public figure suffered injury to her reputation as a result. Now, he's saying that a revenge porn law should be determined to be valid and is not an affront to the First Amendment. Now, we had a few questions for him. I said, well, it's revenge porn, but in creating the pornography, it was consensual. So if a person create these videos consensually, how then can they be banned under the First Amendment? That was the question. His answer was that the pornography was created consensually. That part was true, he said, but it was created consensually for the use of certain individuals, the individuals who were participating in a production. He said that the material was not created to be released to the general public. And that's why he believes that the First Amendment should allow for laws to restrict the dissemination of revenge porn. So let me turn over to his position. So he says, of course, we have cases dealing with defamation, and then we have the case about Falwell, and we have other cases. In terms of pornography, the test that we've articulated, that the court has articulated, is the Miller versus California case. But here he says that when materials are shared, materials that were created with consent when they are shared without a person's permission, then government should be allowed to regulate or to punish the sharing of those materials. So what do you think? Do you agree with him that government should be allowed to punish the distribution of revenge porn? Or do you disagree with him and believe that revenge pornography ought to be protected under the First Amendment? Make a note, all of the titles are listed below, and you can see whether you are agreeing or disagreeing with most of my students' positions. Okay, let's go to the next one. It also deals with obscenity. The student argued that any pornographic depiction of minors under the age of 18 is unprotected speech because minors cannot and will not be porn stars under any circumstances for themselves or for the adults who exploit them. Now, as we talked about earlier, and if you don't know, go back and review, we looked at Miller versus California, where the court laid out a test for obscenity. And if materials are legally obscene, they are in an unprotected category and government may regulate them more. Then the court said, well, there are certain sexual depictions of children that may not be obscene legally under Miller, but in a case called Ferber, the court said government can regulate that too, because we need to dry up the market of child pornography, where actual children are used. We talked about another case of Ashcroft, where the court did not go so far as also including depictions of children where it was not an actual child used in the production of the material, at least not so far at this time, perhaps. I know. So in her statement, she says that any pornographic depiction of minors under the age of 18 ought to be unprotected. Any of it at all. Now, she added in her statement that minors will not be porn stars for themselves or for the adults who exploit them. Now, my question I had for her was, what then, if government is allowed to even more freely regulate this material, what about if minors themselves are creating the material? You may have heard about sexting or minors sharing sexually graphic text messages or videos with each other. My question for her was, if we use the approach she seems to be suggesting, then that could make a 13, 14, 15, 16, 17-year-old then a sex offender for sharing certain materials with their, with their friends or with their classmates. And was she taking it that far to criminalize this behavior, even if it is a minor who shared the depictions? Well, she stepped back, it seemed, a bit and said she would not want to criminalize minors who are sexting or sharing these depictions of themselves, she thought that a better approach would be to use education about this, education with the parents so that they may work with their children for them to understand the gravity with doing these things that may seem, I don't know, somewhat harmless maybe. Maybe it seems that way to the teenager, or the teenager is doing so and sharing these images just because others are doing it. So she did not think that a minor should be made criminally liable for sharing certain depictions of themselves, but that it should be outlawed and there should be some educational process put in place. She talks about the danger of the distribution of this material. And for this reason, she said she does not support this exploitation of children to be porn stars, even if the material was initially distributed by the minor, him or herself. So do you agree with her that we need stronger laws not protected under the First Amendment related to pornographic depiction of minors? Or do you disagree with her position? Remember, keep a record so you can see where you stand. Now, the next two position statements that we covered in class dealt with speech and privacy, or speech and privacy rights confrontations. They specifically dealt with protest speech at medical facilities that provide abortions. So, and we've talked about, well, privacy rights and the federal constitutional right to an abortion. We talked about in a con law video clip. And earlier this semester, we talked about certain regulations where speech was involved outside of these clinics. And I've given you the names to relevant cases. Also, let me point out for these statements, but for all of the statements, there are some cases that you can take a look at. I'll mention them in the text box below as you decide whether you disagree or whether you agree with the law students. Okay, here's the first statement. The first statement is why speech should be more heavily regulated at or near medical facilities which provide abortions and or abortion-related services. So she, in her statement, she says she does believe in free speech rights. However, where that speech occurs right outside a medical facility providing abortion services, she believes that speech should be more heavily regulated. And she refers to here in Jackson, Mississippi, there is an abortion clinic where there are frequently protests right outside the clinic. So her argument is, let me turn over, her argument is that while she is a proponent of free speech rights, there are some issues here just relating to safety, just relating to safety of the individuals who are seeking to enter the clinics. And that's why she argues that when there is a conflict between speech on one hand and the ability to exercise one's privacy rights on the other hand, She believes here that the privacy rights should prevail and that the speech ought to be regulated by government more. Now, she admits that there are some competing positions. One competing position is, well, the laws already allow for a reasonable time, place, and manner, content neutral regulation. We talked about this earlier this semester too. And she said one competing position could be those protections are enough. But she says that where privacy rights are involved, that the protections to the women or those who are entering the clinic should be more. The government should be allowed to regulate that speech outside more. I asked her a question, and I asked her if it helped her argument or harmed it. I said, well, for example, when people go to vote, there are certain restrictions. Individuals who have signs and what have you, they have to stay back so many feet. They cannot approach individuals who are attempting to go in and vote within a certain footage, whatever, because the voting right seems to be more paramount to the speech right. And she said that does help her argument. And so here she's arguing that privacy rights should prevail more and government should regulate the speech more if the speech is in proximity to the medical facility providing abortions. What do you think? Do you agree with her? Do you agree with her position, or do you disagree? Make a note. Okay, now the final position statement, also related to speech and abortion. So this student argued the First Amendment and the right to privacy. The rights of privacy are paramount. Now, his argument was quite similar to the argument that I just told you about, where the student was arguing that the speech outside the abortion clinics should be regulated more. And so in his position, he said that even if you apply strict scrutiny, the government does have a compelling interest in protecting the privacy rights of the women seeking to enter the clinic and in protecting their safety. Now, when I went back and looked at his title, he said the rights of privacy are paramount. So this is the question I had for him. I wanted to know, is he saying that with all of the rights in the Constitution, privacy is more important than speech and other rights? Because that's what his title suggested, that the rights of privacy are paramount. and he gave me a little giggle, a little laugh, because he said, Professor Kapenda, I was trying to do a title that really pops. He says, I believe that the other rights are to be protected just as much. But I said, the court has not said of yet that one right is more paramount than the other. Often people argue that the speech right is paramount because it comes first in the Bill of Rights, but the court hasn't said that. We have equal protection rights, we have privacy rights, we have all kinds of rights. And he's saying the privacy rights are paramount to the speech rights. But he backed up on that statement. and told me he was trying to give me a catchy heading, right? So his statement, again, you can decide whether you agree or disagree. We're going to go with his statement as he wrote the title down for you to cast your vote. He said, the First Amendment and the right to privacy, the rights of privacy are paramount. So as you can see, these students did amazing work in articulating their positions and also in articulating the positions different from their own. I told them they all did a great job, but I also added, just because I say they did a great job does not mean I agree or disagree with their statements. As their teacher, my job is to make sure they complete the exercise, make sure they can argue their position well, and make sure they also know how to address and anticipate the disagreement with their position. We had an amazing first day, and we're going to come back and talk about twice a week. I'll be back to tell you about the other position statements that were offered by students in class. Isn't learning wonderful? Learning takes us on the path to enlightenment, and enlightenment takes us on the path to freedom and justice, or at least to a taste of justice. So subscribe and sign up for notifications. We have more student position statements to come. And I'm telling you, you don't want to miss a thing. So thank you and see you next time.